Good morning. We'll now open the Senate Children and Family Law Committee. Senator, lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We will now open the public hearing on Senate Bill 278, including qualifying convictions from other states as grounds for termination of parental rights petitions. Floor is yours.
Good morning, Chairman Abbas and members of the Senate Children and Family Law Committee. For the record, my name is Tommy O'Neill, Minority Caucus Director, and I'm here on behalf of Senator Suzanne Prentice, who represents the communities of District 5, to introduce SB 278. She's the prime sponsor of SB 278, being made at the request of the New Hampshire Department of Health and Human Services. The bill seeks to amend RSA 170C5 in response to the New Hampshire Supreme Court decision in the matter of HC 176 and H 248. Specifically, the amendment clarifies that qualifying convictions for termination of parental rights to include or the equivalent conviction in a court of competent jurisdiction. Members of the department are here to speak on SB 78 and to take any questions from the committee. Thank you for consideration of the bill.
Thank you very much. Susan, you're up.
Good morning, Chairman Abbas, Senator Sullivan, Senator Long. Good morning. My name is Susan Larrabee, and I am General Counsel and Legislative Liaison for DCYF. By way of background, currently Chapter RSA 170C describes the civil process of a petition for a termination of parental rights, which can be brought by a parent, a guardian, or legal custody of a child for certain conditions that are described in 170G5, entitled Grounds for Termination. And contained in Roman numeral 1 through 7 of this section, this bill itself pertains to Roman numeral 7, in which the grounds for which termination can be brought for certain convictions of one or more of the following offenses as laid out in Roman numeral 7. Murder of a child, parent, or a sibling, and labels it as pursuant to RSA 632. Manslaughter, again, citing pursuant to RSA 632. Attempted murder and manslaughter of those same individuals, or assault in the first degree, second degree, aggravated felonious sexual assault of those individuals previously mentioned. This section of the RSA was enacted in 1999. And again, it references New Hampshire criminal RSAs, but doesn't expressly state or the equivalent of another state, which, interestingly enough, is added to another section of that chapter, which was added in 2018, 170C5A, which references another grounds for immediate termination of a parental rights of a child when that child was the result of a sexual assault against the mother of that child. And does reference that the sexual assault may also be found in another jurisdiction of equal jurisdiction of another state. This very issue did go before the Supreme Court in In Re HC, decided on November 14th, 2023. Referencing 2022-0257 as the docket number. And I did bring copies of that Supreme Court holding. Although the Supreme Court ultimately looked to the statutory intent of that statute in upholding the termination and saying that it was the intent of the legislature because it would have illogical results. That you would hold that RSA of manslaughter and murder and the other delineated offenses would only apply to crimes of that nature in New Hampshire and not the equivalent outside of the state of New Hampshire. However, there was a strong dissenting opinion by Chief Justice McDonald in which he references that, and I'll quote, "Our statutes are replete with provisions enacted over the years demonstrating our legislature taking into account in a variety of contexts the potential applicability of laws of the other states," and points to various sections of the RSAs that does note that it is not only the crime in New Hampshire, it's also the equivalent conviction of another state of competent jurisdiction, and does itself cite to the aforementioned reference that I mentioned within Chapter 170C 5.8. And basically, although it's a precedential case, we do believe that the general public should be aware and understand the plain meaning of the language, looking at the four corners of the statute, especially with a statute like this that can be brought by a non-attorney, can be brought by a parent or a guardian of the child. And for those reasons, we put forward this legislation and thank the Senator for sponsoring this bill. And I'm happy to take any questions.
And just for some clarification for the committee, if you don't mind.
Sure.
So equivalent conviction, I understand what that means, but maybe I want to explain to the committee what that means.
Sure. The standard of proof for the termination of parental rights is a beyond reasonable doubt consideration. So by law, they would be looking at that, did the state prove or the guardian prove or a parent prove beyond a reasonable doubt that other parent was convicted of the crime of manslaughter. And we would look at how it's defined in New Hampshire and then look at the outside states. Say, in this case, it was a Maine case of sexual assault against a child. And are those two statutes comparable? Do they have the same burden of proof? Do they have the same elements to make that a delineated crime of manslaughter, murder, or the assaults that are delineated in these provisions?
Thank you. Senator Long?
Thank you, Mr. Chairman. So with respect to when this would take effect, I know January 1st of 26, but can you go back? If 5 years ago there was a charge in another state, would you be going back, or does this begin on January of 26 going forward?
Well, again, as the Supreme Court upheld the determination of a parental rights of a mother who was convicted of sexual assault in Maine, we would not need to go back because it was already applied that way. It's just going forward by looking at the four corners of the statute, whether you're a lawyer or a non-lawyer, you would understand that if a parent was convicted of those offenses outside of New Hampshire, that you would have the ability to bring forward a termination petition.
Okay, thank you.
Seeing no questions, I want to thank you for your testimony.
Thank you very much.
Are there any members of the public who wish to testify on Senate Bill 278 that have not testified already? Seeing none, we'll now close the public hearing on Senate Bill 278. And the committee will be in recess for 5 minutes to 9:45. Now, we're now back in session. Is there a motion to go into executive session?
I so moved.
Second.
We're now in executive session, and I will now. I can,
I have a motion to leave executive session.
Second.
all those in favor?
Aye.
Nay. The ayes have it. We now open the public hearing on Senate Bill 161. Senator Birdsall, the floor is yours.
Thank you, Mr. Chair. Thank you, committee, for hearing my testimony on Senate Bill 161. There isn't an amendment. I just received it this morning, so I'm going to presume that the language is similar. The intention is the same. I'm assuming that the language means the same. So for the record, my name is Regina Bursell, State Senator for District 19, which encompasses the towns of Derry, Hampstead, and Windham. I'm the prime sponsor of Senate Bill 161, and this was a request of the New Hampshire Department of Health and Human Services. It's remedial legislation to Senate Bill 417 from last year in Chapter 377 Laws of 2024. It's consistent with the underlying intent of its predecessor. Senate Bill 161 replaces references to placements for children contracted with the department with placements in New England deemed necessary and appropriate by the court. Members of the department are here to speak on Senate Bill 161 and to take any questions from the committee. Thank you for consideration of this bill.
Thank you. Seeing no questions, I want to thank you for your testimony. I don't have a list, but some of the departments here.
Good morning again. Susan Larrabee, DCYF General Counsel and Legislative Liaison. Thank you, Chairman Abbas, Senator Long, and Senator Sullivan. Yes, I will be speaking on behalf of the Replace All Amendment. By way of background and some context, last legislative session, House Bill 1573 and Senate Bill 417 enhanced, expanded, and codified the oversight of children in residential treatment at all levels of the process. It enhanced and expanded the certification process and the monitoring of those certified residential treatment placements by the Bureau of Children Behavior Health within DHHS. It enhanced and expanded the oversight of residential treatment placements by the court, in which the court now must approve and order residential treatment placement, a very specific residential treatment placement for that specific child before that child enters any residential treatment placement. And it enhances and expands the oversight of children in that residential treatment placement with increased oversight by the caseworker at each monthly visit with the child, as well as with increased oversight and reporting out of everything that is seen during that 30-day meeting with the child and touring that residential treatment placement. Over the summer, after this took effect, DCYF, along with all the stakeholders, especially the Office of Child Advocate, who were the original writers of a lot of the language within those two bills, worked many sessions to not only internally update multiple policies, SOPs, forms, several trainings occurred to implement and operationalize both Senate Bill 417 and House Bill 1573. We worked collaboratively with our Bureau of Children's Behavior Health, and we worked collaboratively with the Model Court, the Court Improvement Project, with many stakeholders involved in that process. During this process, we discovered some inconsistencies and technical differences between the wordings that came out of House Bill 1573 and Senate Bill 417 and addressed them in this replace all bill. There were many iterations of both bills as they made it their way through the legislative process last term, as well as the committee of conference that occurred at the end of the session last term. And I will point out that House Bill 1573 and Senate Bill 417 had the intention at that time during all of the processes to replace the term contract with the language license in accordance with the laws of the state in which they operate and are certified by the department every time the term contract was used. But inadvertently, two sections referenced in this bill were not changed. So thus, that's the reason for page 1, lines 14 through 16 of the replace all, and page 1, lines 26 through 27 that were not changed. And as a result of this replace all, they will be consistent with the entire sections that were affected by Senate Bill 417 and House Bill 1573, as well as aligning the circumstances of when director approval is necessary for an out of New England residential treatment placement that now will align the RSA with what was codified in RSA 169 F19, in which on page 1, lines 19 through 20 language, as well as page 1, lines 31 through 32 language. And then finally, on page 2, line 4 of the replace all is purely a Scrivener's error that is now fixed in terms of it references the correct subsection, which an error was not addressed originally. And I'm happy to take any questions or field any concerns about the replace all amendment.
And seeing no questions, I want to thank you for your testimony.
Thank you very much.
If I recall, that was a pretty contentious committee conference.
It was, and it was the 11th, I want to say the 11th hour in terms of timing. So it's not surprising that there were some things that came out that we didn't realize
A Scribner's
until
error, I'm not
the
surprised.
implementation.
Yes, I think I was a witness to some of that.
But I will say that after that, we've all worked very collaboratively over the summer, and we're operationalizing and implementing both bills.
It was mostly us elected officials arguing ourselves, but that's all right.
Thank
I
you.
appreciate it.
Thank you.
At this time, the chair will recognize Cassandra Sanchez.
Good morning, Cassandra Sanchez, Child Advocate for the State of New Hampshire, and I have with me today
Attorney Lisa Massio, I'm the Associate Child Advocate and our Legislative and Policy Director. We are here to support the Replace All Amendment, and we're happy to offer any more information or answer any questions you may have. Senator Abbas, you are correct. It was quite the haul last year to get this through. There was a lot of back and forth, a lot of amending. So the Replace All Amendment does accurately reflect the intent to support SB 417 and HB 1573 with those couple of corrections. Specifically, the error had been in when director approval was needed. In some versions, it said outside of New England. Some it was saying out of state, which is just outside of New Hampshire. So that was causing some confusion. So we're really just here to answer any questions.
Seeing no questions, I want to thank you for your testimony.
Thank you.
Are there any members of the public present who wish to testify that have not testified already? Seeing none, we'll now close the public hearing on Senate Bill 161.
I'd like to make a motion to go into executive.
Second.
All those in favor?
Aye.
Aye. We're now in executive session. I think we start with Senate Bill 278, and I can make a motion about it to pass.
Second.
I will say that although I appreciate this because I read the dissent and I might actually, you know, my legalese might actually agree with the dissenting opinion, but I don't, you know, the plain writing of the RSA, I think it's better to correct it. And I think it was well explained that, you know, the retroactive application normally wouldn't be allowed, but because the Supreme Court case, they would be covered under that. But I think this is a good housekeeping measure to address that. So, I'll move the motion about to pass. All those in favor?
Aye.
Aye. All those opposed? The ayes have it. Motion for consent.
So move.
Second.
All those in favor?
Aye.
Aye.
And I could bring it out if you want.
Senator Long can bring it out. Easy. We now move to Senate Bill 161. I will say for my colleagues that weren't involved in the committee conferences last year, this one kind of got, well, there's a lot of back and forth on a lot of different bills, and this one kind of got mixed into a lot of different things. So, you know, there's sometimes at that 11th hour when you have to sign off on things, there can be some mistakes in the bill. Scrivener's error. This addresses that. So I'll recognize anyone for,
I'll make a motion to, as ought to pass for Senate Bill 161.
I'll second.
Second. Oh, go ahead.
Senator Long seconds. And does anyone wish to offer an amendment?
I'll move amendment 2025-0514S.
I'll second.
So all those in favor of adopting the amendment?
Aye.
Aye.
Aye. All opposed? The ayes have it, so the amendment's been adopted. So now the motion is ought to pass as amended.
I'll make the motion not to pass as amended.
Second.
Any discussion? All those in favor say aye.
Aye.
All those opposed? The ayes have it.
I'll move consent.
I'll second.
Okay, so all those in favor of consent?
Aye.
Aye.
Aye. All those opposed? The ayes have it.
I'll take it out if you want.
Perfect. I get a feeling the next one's gonna go just as smooth. So the only bill we have left is Senate Bill 72. And I do have an amendment. I know it's just been handed out. I can reference, if it would make it easier, I can reference the page and line numbers of the original bill that it addresses as we go through it. If there's any questions? What was addressed, what not was addressed? So first, I think it's in order to make a motion about to pass.
I'll make the motion ought to pass on Senate Bill 72 FN.
And I'll second. And this time I would offer amendment 2025-0527S. And I'll just go through it right now, just to. I can reference the page and line numbers of the original bill, because this doesn't, the amendment won't, you know, it's kind of, it's not a replace all, so it'd be a little hard to follow. So the compelling state interest, if you go to the original bill on page 1, line 24. That part of the amendment just essentially rewrites the first sentence. I think it makes it a little clearer. I don't think it changes the intent or.
Thank you.
Oh, okay. Okay, yeah, I see that.
The other part, if you go to page 2, lines 2 to 3, I think during the we opened an executive session, discussed this. I think there was some concern about whether or not this would apply to private schools, particularly, if they had one EFA student. The issue that I came up with was, well, a private school could have one EFA student, and then all the students would fall under this. And speaking with some of the prime sponsor, particularly, it was really not the intention was not for this to apply to private schools. I mean, that's a policy consideration we can take up, but the amendment would take that last line out and then adds an or to make the grammatically correct before public charter school. But it does take out the section on any school or entity that directly or indirectly receives state funds for education. I read that as applying essentially to an EFA student. So I think if the intent was to not include private schools, unless there's a disagreement that we want to include private schools, which that's a policy consideration. So that's part of the amendment.
Okay, that's Roman numeral 4.
There was a typo or another Scribner's error on page 2, line 7. It said impingement. I think it's supposed to say infringement. So that's a grammatical change.
Yep.
And then on same page, line 8 and then line 10, it says the knowing provision. I just said knowingly. So it's that was more grammatical than any material change. If you go to page 4, line 12, we had a discussion on whether mental health treatment should be included in that. I read it as already including mental health treatment because that's technically a medical procedure, but I think for clarification purposes, not everyone agreed with my interpretation. So I think it made sense to just add mental health treatment. So we add including mental health treatment.
Okay, including mental health treatment, which some of that is already confidential, right? I don't know if the confidentiality would be waived with this.
Well, it's the right to
Adding
be
this?
informed of and provided consent to the mental health treatment. The issue of confidentiality
Oh, I see what you
is,
mean. Yeah.
but
Okay,
and then
okay.
you have the 2 RSA that are listed, those exceptions, those aren't impacted by this, but that exemption still would apply. The same page, if you go to lines 14 to 17, although I agree, fundamentally with everything that paragraph says, that's just a reiteration of existing constitutional rights, and it did not need. I don't think it needed to be reiterated there. I was surprised to hear some people objected to the language, which I was shocked. But you have freedom of speech, freedom of. I mean, that's just we're talking constitutional rights. But in a criminal statute, they don't mention you have a right to counsel, and
Right.
you don't need to reiterate that because it's already the foundation of our Constitution. Literally, it's the First Amendment, and you have the right to due process. I mean, because that's being codified in the RSA. That's not even, in the enactment section. So
Yeah.
we felt that the language wasn't necessary, so that's why we took it out.
Okay.
If you go to page 5, line 16, I think there was some concern about the word superior, where it might be perhaps make it more clear who that's referencing. So
Yep.
it's I put the word principal or designee to make it clear There'll either be someone designated by the principal on who that report would have to be made to by the teacher or by the school staff or the principal directly. So I think that's more clarifying language than,
What page was that on the amendment?
oh, it's page, so the original bill, it's it's amending page 5, line 15.
Yeah. Okay.
It's line 16?
It is line 16. Good catch.
Okay. 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 Yep. So,
I also struck the section on page 5, lines 10 to 12. It had to do with the awarding of attorney fees in the event that a plaintiff or a parent was unsuccessful in a lawsuit. There's already a remedy for a frivolous lawsuit. If it's completely frivolous, that there's a remedy that can be brought. There's an abusive process claim as well that can be used. But merely the fact that someone's unsuccessful doesn't mean it's frivolous. So they would have to have some foundation for their claim. So we took that out, and it's in most civil cases, an unsuccessful plaintiff is not responsible for the other side's legal fees. Knowing that there's obviously the remedy for frivolous lawsuits already. So this would be more of an anomaly to have that than,
okay, so it may not be a frivolous lawsuit. So the district wouldn't be going after the parent for a frivolous lawsuit. It just a disagreement or whatever.
well, well, I'm not citing the exact legal definition of a frivolous lawsuit, but if there's no foundation, no factual support for your claim, and you just file a complaint and it's not there's no evidence of any of it, and it's in those cases, it can be, one, frivolous, but two, abusive process. You can raise that as a civil remedy, saying that this
Right.
lawsuit has no,
Yeah.
it doesn't even meet, and and that's up to them to bring it. Also, if they retain counsel, there's potential remedies against the attorney as well, if they're represented by counsel. So if a lawyer brings a frivolous lawsuit, there's an additional,
Yeah.
the lawyer can be sanctioned. So
Yeah.
not saying it doesn't happen, but
Right. Yeah, I'm anticipating that it's not going to be that clear cut. I think a parent's going to bring an action against the district. And it's going to be deemed that it wasn't frivolous, it was a misunderstanding or what have. So I think a frivolous lawsuit is, you're not going to see many of those, if any.
certainly not recommended.
So I don't see where the taxpayer should pay. However, if the parent wins, the taxpayer should pay the attorney fees and what have you.
But look at it from
The
a,
other way.
look at it from any type of claim against a city, a municipality, whether it's a claim against the state. The taxpayer's paying to defend those lawsuits.
Right.
And it can be a civil rights action, it can be a personal injury claim. I mean, zoning. We just a lot of these, and for the overwhelming majority of those, if a plaintiff is unsuccessful, they don't pay the legal fees. So I'm just saying that the custom is that's
Okay.
this would be an anomaly to require that. That's all I'm saying. So
Well-
that's the reason why I'm taking it out. If that was universally practiced, throughout the state, different story. But it's rare that would apply. Considering that if it's really a outrageously frivolous lawsuit, there is a remedy. I think that's ultimately what they want the protection from, and I think they have that already.
So with respect to municipalities of the state, the taxpayer pays for the court battle. However, more times than not, they settle to avoid that court battle. I don't see no settlement here.
Well,
You know, so that's the advantage, that where we save tax dollars instead of bringing it to court, settle, and a lot of times it's, even though you know you're gonna be found guilty of that,
it depends.
you'll settle to save money.
I will say it depends on the municipality, right? They all have different attorneys. Some settle, some don't. In respect to the state,
Yeah.
same way. I think usually when there's a settlement, it's because the plaintiff has a really strong case. But my experience, they don't just roll over. I wish they did sometimes.
Yeah.
But they
Yeah,
don't.
well, this is a lot, you know, this is a lot less than, you know, somebody breaking an ankle or on a sidewalk, or a plow truck plowed into their car or what have you. You know, hopefully before a parent bringing something, or the school, well, it'd be the parent that would be bringing something, there would be a settlement. That the school would understand, here's what you're looking for, and then we're not giving it to you. You know, there'd be a discussion prior to whether there were lawyers involved or not, prior to having a legal battle.
If
Because that's a risk to both sides. I mean, so,
well, keep in mind if the parent has a really strong case, they are still entitled to legal fees, and that's if they're successful.
Yeah.
So I would hope that school is advised accordingly by the legal counsel rather than running up, because then they got to pay their own legal counsel's bill, then they got to pay the other side if there is
yeah, I agree.
So-
So they would settle. I would hope.
I would hope so.
Yeah, I just don't think that the taxpayer would pay for the courts, and also pay the parent if the parent's successful. I don't, without reversing that, without having the parent pay the taxes back that was used and spent for the court.
So the district would have plenty of opportunity to not let this get to that point where they have to go to court, right? They've got plenty of opportunity to make amends with the parents and make this right. So it gets to that point,
Yeah, it's settled.
it's
They
on
would
the
settle.
district, right?
Correct. Yeah.
I mean, and it's, it's a federal civil rights cases. If you're successful as a plaintiff, you get your legal fees. If you lose, you don't pay the government's legal fees. And those can be brought against the state and municipality. So, I mean, I will say the overwhelming practices this would be inconsistent with that. So I think the amendment at least makes it more consistent. And then this would be adding a section which would, if you go to the original bill, page 4, line 14 is where it would go. It adds a section T. And it adds the language, the right to receive truthful and accurate information about the child in response to a written request that is not otherwise protected from disclosure by this chapter.
Right. So, yeah, I mean, we're just not going to agree. I do agree with the intent of this bill. Giving parents clear, well, I don't think it gives them clear examples. It just gives them copies of statutes and federal code. So I agree parents ought to get that, you know, I just think they ought to get it in an understandable way instead of statutes and codes. And I also, what was the other change? Yeah, so the attorneys, recouping attorney fees, I disagree with that. I understand your argument. The mental health, I don't have an issue with. I just want to make sure that it's, you know, I want to be assured that it's not, it's just a conversation with the parent before any medical procedure is done. That I'm clear on. But in earlier language, there's a confidentiality with respect to, I would say, psychiatrists or whatever, that's in federal code, that there's an assumption of confidentiality in that. But I would think a parent would be getting, asking for information that they didn't know about, which, yeah, I agree they should be asking. They ought to know about that.
So I think in respect to, what you're referencing is page 4, lines 11 to 13. By adding mental health treatment, if, let's just say there's going to be a mental health evaluation performed on the child.
Yep.
This is saying that the parent has the right to be informed of the procedure. Now,
Right.
anything that's confidential or privileged that's a result of that evaluation, that's separate.
Right.
But
Okay.
this is the right to provide consent
Okay.
before it happens.
Yep.
Meaning the evaluation can't just be, unilaterally done without the parent's consent.
So, yeah, I agree with all except, we remove, private schools. Parents have parental rights only refer to public schools. So as far as private schools, they don't have the parental rights. I don't agree with that. And then the other thing was clear and convincing evidence. No one other than attorneys are trained in identifying clear and convincing evidence. I mean, 2 attorneys in opposition go to a court with clear and convincing evidence, and the court decides who has the more clear and convincing evidence. So I think that's a high barrier for an employee to know what that is.
So clear and convincing evidence, I think what was being suggested was we change it to preponderance of the evidence.
Right.
Both preponderance of the evidence and clear and convincing evidence are evidentiary standards. So if they don't understand clear and convincing evidence, then I don't see why they'll understand preponderance of the evidence. If you're able to understand what preponderance of the evidence is, that person should be able to understand what clear and convincing evidence is.
So is preponderance of the evidence a lower barrier than clear and convincing?
It is a lower one, but again, if all the objection was no one's gonna understand it, and I'm thinking to myself, well, why do you understand one but not the other? So that what was presented to me was not did not persuade me to want to change that.
Yeah, I think I could learn quicker preponderance of evidence than I can learn clear and convincing.
Well, they're just both, they have a definition that's, I mean, I would find it hard pressed to say that if you explain them both to someone, they understand one but not the other. So that just from what I received. Now, if you change it to preponderance of the evidence, I suppose, I guess a violation of this law, there'll be a lower threshold that the school would have to, they're basically the threshold to infringe on the parents' rights is a lower threshold. That's what lowering it would do. But that's not what any of the testimony was. The testimony was, I mean, that's at least I can understand why changing it, at least I can understand the argument. That's not what was presented to the committee. Everyone just said they were confused or no one would understand it. I think in this case, if the fact that you have a school official that has to go either to the principal or designee, they have the discretion to consult with their own counsel if they choose so, during during this process. And I think whatever decisions being made by the school, it's not just one person's too. And I would hope, either way they're making an informed decision. And it says in here that they have to articulate why they're doing it. So when they're doing it, it seems to be they're spelling out why they're infringing on the right
And we can ask the Department of Education to put out technical advisory just to break it down and make it easier. They do it for a lot of other laws that we pass
I mean,
that are
they
used by parents.
most certainly could, but I'm just saying the evidentiary, the burden is the burden of, and that's what it is. So I guess,
Yeah, well, I mean, I just look statutorily at other significant family disruptions, DCYF. It's preponderance of the evidence, I believe, not clear and convincing. Probably ask Mr. Williams. You know, I'm just looking to stay consistent. I don't know why when a child's abused, DCYF has the preponderance of the evidence. However, when a parent's rights, if they believe their right has been violated, it's clear and convincing evidence on the opposition to
One is
show.
criminal, like abuse of a
well,
child.
no,
You know.
those are technically civil, but, so look at it this way, we'll go to the, since we were talking about the mental health provision, right?
Yeah.
If a school were to perform a mental health evaluation without the parent's consent, it's we would agree if this is law and the amendments passed, that would be an infringement.
Correct.
So if the school has which there could be a legitimate justification for them doing that, they would have to explain why. I think it should be I think they should have a pretty high standard of explaining why they felt getting the parents' consent was not appropriate or not, that could potentially be harmful to the child. They should be able to articulate that pretty clearly and be very confident with why they're doing what they're doing. And if they spell that out, I think they would, and if the justification is legitimate, based on some actual, they have a foundation for it, I think they meet the clear and convincing standard.
Okay.
You know, if they say this parent has a history of abuse and, we're concerned about that parent, and when they say they have a history of abuse, they provide some detail why they believe that. Maybe there was a DCF involvement that they were aware of. Maybe they were the ones that made the report to DCF in the first place.
Right.
And then they articulate that's the reason why. Whether it's preponderance of the evidence, clear and convincing, I think they pass the threshold, at least in the sense that explaining their conduct. I think holding them to a high standard, if they're going to infringe on those rights, they should have more than, oh, I heard this.
Right.
Simple.
Yep. Yeah, so I still have the,
You still like preponderance.
I do. For some reason, it's a lower standard for me. That I'm thinking, I'm not an attorney, but
So
it's a lower.
would that change bring you on board to support? amendment?
It would bring me closer. No, I don't. Like I said, I have there's three issues.
As far as the private schools go, we know the impetus for this is what happened in Manchester. That we know that public schools have put out policies that will prohibit parents from having access to information on their children. We have not seen that come out of private schools.
Well, I
So-
personally had that when my son was going to private school. I had that issue where I had to leave the private school.
That was the
But that was
resolution,
years ago.
right?
That was years ago, and this wouldn't help me today. I don't have any rights if I'm in private. If
You,
my
you have the right
kids
to
go on.
leave.
I have a right to leave, as does the public
Most,
schools.
Well,
They don't have a right to leave?
a
well,
lot of kids and a lot of families in public school. Well, that's the argument that is always made against EFAs, right? That not everybody has a chance to choose a school.
I've never
So-
made that argument.
It's been said. So
not by Senator Long. but
Not
it's
by
been-
Senator
But
Long.
it's been said.
it's been said
Yeah,
that, so it's if a child is in a public school in their neighborhood and they don't have access to something else, right? But we and I'm sorry that happened to you, but a lot of these conversations came out of what was happening in Manchester and the policies around that schools are making. I don't know of private schools that have made policies. They may have had behaviors that kept parents in the dark, but not policies. And we're seeing policies put into public schools to keep parents in the dark.
What I can say, there is a distinction that I make, and I'm not sure it's going to persuade you, but when a family enrolls their child into a private school, they're doing it voluntarily, right?
Yep.
Now, by doing it voluntarily, that's their choice. They're essentially waiving their rights under this if this becomes law. In a public school setting, there's truancy laws. That you can't just take your child out of the public school. Some people have the means to do it, but not everyone will have the means to take their child out of the public school and send them to a private school. Can they, legally do it? Yes, but they don't have the means of doing it. And also, because of that, and we have truancy laws. I mean, they can't just keep their kid out of school. Not everyone has the means of providing homeschool. So in that scenario, it's not the same voluntary situation, if you ask me. So
Yeah.
if someone, I didn't hear any. My understanding was the intent from the sponsor was to not include private schools. So the idea was, well, we didn't hear anyone really advocating that it should apply to private schools. I'm not saying that I'm opposed to that fundamentally. It really wasn't discussed during the public hearing, and I think when it was first pointed out, I was like, huh, that will. So let me look into that. I'm not. Perhaps maybe we would revisit that at a different time, but I think for now, I would be more comfortable sticking with the intention of the bill was to not include private schools. And then in fairness to the private schools, if there was a standalone, they can come and plead their case one way or another. If they don't show up, then I take it there. But I think we can consider that policy at a later date. I'm open to changing this in the future.
Okay. Yeah, so this Senate Bill 72 asks that the districts give these statutes and federal code to all the parents so they understand their rights. And it also asks for on page 4, lines 20 of the original bill. The right to receive information, including student reports, in an understandable and uniform format. And I don't think given a brochure of statutes and federal code is a language that parents can understand.
Well, no, I think that we can ask the DOE for technical advisory that they
What-
do that for other bills all the time that they put out.
What page in line?
Page 4, line 20. It's a federal code.
Well, I would assume, at least I would hope, the school's already, complying with those federal codes.
Yeah, but we're in this bill, we're asking them to hand out statutes and federal codes.
I don't think they have to, per se, hand out this law to parents.
Well, that's what the sponsor, I asked that question during the testimony, and that's what the sponsor had said.
I don't think that it's we got to hand this out. But the problem that happened, this happens in a lot of different areas. We had it with victims of violent crimes, where they have so many and rights under the RSAs, but they're all over the place. And when someone's trying to do their own independent research, it can get a little difficult finding everything. And we call it, we always assign the term Bill of Rights to it we've had other Bill of Rights type bills. We basically take a lot of things that are already out there and we're just putting it all together. So if someone is trying to look into what their rights are, it's much easier to find. And I mean, if someone, in my own private research, I've found laws that are, 100 chapters, the affirmative defense is 100 chapters away from the charge itself. It's way in another land.
And that says annually. So with the student handbook that parents receive at the beginning of every school year, it could be included in that.
Yeah, that's not an issue. It's just, I mean, the district has to let parents know of their rights, parental rights. And how else would you do that other than start, giving them a copy of the statutes and federal code?
Well, I don't think you have to give them the actual federal code. I think you have to basically, what's written in here, I think the reference to the federal code is all is needed.
Okay, so give them references to the statutes and the federal code.
So in a student handbook, basically the RSA itself would be sufficient. You wouldn't need anything beyond that. They don't have to, per se cut and paste it into there, but every RSA and federal law or whatever regulations reference, I don't think you have to then supplement that with an actual copy of the RSA or federal code. I don't believe that's necessary.
Okay, so just let them, I mean, this is recodifying, parental rights. I'm on board with that. I do believe that is necessary. It's been years ago, but I never knew what my rights were. Although there were plenty of statutes out there that would give me that information. So given that knowledge, to the parents, I think it's a good idea. But again, so in your mind, if this bill goes through and signed by the governor, what would the district be required to do?
So obviously on an annual basis, this written notice, again, I think the student handbook would, it's also, keep in mind, written notice, I think, can even be done electronically as well. But they would be required to inform the parents of their rights. And I think what those rights are pretty well spelled out throughout the bill. Or what those
So
disclosures.
giving them a copy of the bill as it passed? Or actually it'll be placed in statute, so give them this,
That would be one way of doing it. I know they have, I suppose they could paraphrase. I'm not sure it might be easier to just have the RSA in there.
okay? Okay, so,
I feel like if you were informing someone of their rights and, you paraphrase, but, some of these include reference RSAs or federal codes. If you don't put the reference to the federal code RSA in there, I'm not sure that's recommended.
so the districts are giving them the, the same, like the right to notify whenever seclusion or restraint has been used on a child as set forth in RSA 126U7, that's all they would have to put in. That's all, the advice that they would give the parent.
It's simply advising them of their rights.
Okay.
It's nothing, nothing beyond that. No, they don't have to provide any legal analysis, any further explanation, of that, the origins of why, that's a right. And
Okay, yeah, and I just think that there's gonna be a lot of different handouts, with different districts. They're gonna come up with their own interpretation or whatever. So,
if we had to leave that to the local control. If
Yeah.
they want to paraphrase this and rewrite this and make 7 different handouts, that's probably the least efficient way of doing this, but we didn't mandate on how they have to do it as long as it's in writing.
yeah,
I mean,
okay,
Again, we can ask the DOE to do technical advisory and then they can adopt that language in what they do. So then it would be consistent.
well, if you can put in one letter versus 7,
Right.
I don't think we get to advise them to do that. I mean, if the department wants to, I'm all about that, but I mean, I think the handbook would be a great idea. Obviously, they may not have every parent's email, but I think, emailing this, I mean, we're talking about, and it's going to be the same document sent out every year. It's not, provided there's no changes in the law. So I would assume that, I'll leave it to school and how they want to do that. I am hoping they do it in the most fiscally responsible way, but that doesn't always happen, so.
Yeah, it's up to them, yeah. So, okay, yeah, so I have an issue with the preponderance to clear and convincing. I think our statutes on that, as I said, is preponderance of the evidence. And then also as far as readable, a document that parents will understand. I think if they copy something like this, I think it's fine. Right, it gives you what your right is, and then it gives you the statute that refers to that right. So I think that's fine. And four. Yeah, I think that's an understandable uniform format. 6. Yeah, I don't agree with the recouping of attorney fees on one side. I think it ought to be on both sides.
I hope you at least support the grammatical errors that I corrected.
Yeah, that's a no-brainer. Yeah.
Partial,
I mean, I'm
partial
just
agreement.
gonna have to look up the mental health. I understand why that's necessary to put in there. I just want to be sure that it's not circumventing the, at the beginning where it's, there are some, students have a right to some confidentiality. And it doesn't appear right now offhand that it does infringe upon that. I just want to.
We have another bill in education that parents have to sign off on any medical, anything.
Right.
So it just,
Okay,
it backs that up.
Okay, yeah, so those were,
So,
oh, and then I also, the only other issue I have is if, okay, the parent wins. So there's a coach who didn't reveal something to a parent. So the parent goes to court, the parent wins. Can she go after the coach?
I think
I think she can. I think the parent can go after the coach
my understanding,
and have a better,
so this says it's against, if you go to page 5, lines 6 to 7, and it says, any parent claiming a violation of any provision of this chapter may bring an action for declaratory or injunctive relief in monetary damages against the school.
Yep.
So it's not the individual coach.
no, it's against the school.
It's
Correct.
against the s-
However, as the parent, so I've already proven that the school was wrong, that this coach was wrong in not providing me that information. And here's the damages I have on that. So could I go after the coach for civil action?
Well, so technically, yes, but that's existing law. So depending,
Yeah.
my point is under this chapter, this bill, if this became law, the remedies that are available are only against the school. If the coach did something that is already, would subject them to civil liability, they could do that. That still exists today. But this is, if they bring it under this, it's only the school.
Right. I know that this is only the school. However, in a school, I'm sure would tell a coach, yeah, you need to give that information. The parent has a good case against me. What I'm saying is every time the parent wins, they could civilly go after and have a better case. Why? Because they already showed the school was at fault.
So let's say, so the scenario hypothetical is the student says something to the coach goes to the principal, or the designated, they don't sign off. They say, no, this, you gotta disclose that. And then the coach doesn't. Well, I mean, first of all, that coach, it's up to the school and their personnel decisions. That aside, I mean, I think the principal or designee should probably
Yeah,
make sure and follow through to make sure it's actually
Yeah,
disclosed.
I get that. It's when the school agrees with the coach. Yeah, we shouldn't be,
And-
we don't have to tell that parent.
And
That's
in
confidential.
in that case, that's where the infringement is. I don't think there's an infringement by the coach withholding it going to the principal. I think in order for that to occur, it has to be, it's when they make the determination is the non-disclosure is going to be, they're not going to disclose it. Now you have that scenario. All right. In that scenario, the coach is being supported by the school, the principal, right? Or the designated. The school's backing up their initial decision to not make the disclosure. Whether they're violating, if the court says that no, the principal and the coach are wrong,
Right.
that claim is against the school, not the coach.
No, and I understand that in this bill, it's clearly against the, but it's given an opportunity to do a double, once I get a decision that I was right, the coach should have disclosed this to me. Now I go after the coach, even if the school claimed that, yeah, you know what, I believe that's under confidentiality to this federal code. You don't have to disclose that.
Well, first of all, you can recover your monetary damages. All right.
A parent can when you win,
So-
yeah.
Again, if there's if they have a claim against the coach as well, I think it's wise that you would bring them all at the same time. Like this would just be one of the counts in your claim. But I'm not 100% that they could be brought separate. It's the practice is to bring them all together, not have, because you have the same interested parties, because then you have issue preclusion, claim preclusion. You don't want to have, inconsistent findings. But
Yeah, it's,
I see what you're saying, but I don't, I think the law already addresses what could be done in that case. And
yeah, I think it opens up the coach or the janitor or whatever.
well, they would already be subjected to liability though. If they are open for anything, they're already subjected to, that claim can already be brought under existing law if there's a civil remedy in some other RSA or common law.
Right.
That doesn't
But-
change.
But as a parent, I wouldn't bring that forward if I didn't get if I didn't win against the district. If I lost against the district, I'm not going after the coach. I already lost and with the district. The court already deemed, no, the coach was right, or the district was right. And advising the coach, don't give that out.
So then they wouldn't, I'm much clear they would have a claim against the coach. The
No,
coach,
they wouldn't if they lost, but if they won, they would.
potentially.
Even if that is the scenario, that they have a right to do that. They've been proven they were right in pursuing this. So
Yeah, but if the
even without this, though, they could go after anyone can sue for anything,
right.
right?
Yeah, no, I understand that. Yeah, I understand they could go after the coach immediately.
Right, but
But
this
now
only
that-
speaks to the district.
I don't know what that claim look. I'm again just a simple, a clear violation of this. I'm not sure it necessarily creates other causes of action.
Well, it gives you a better cause of action.
Well, it
If you
depends.
win, if you win, if the court says the school district was wrong, you got a better case.
So if the coach would say was secretly administering anabolic steroids to make you a super stronger, faster athlete, I guess that we can say, we'll just say that's a medical procedure. fine.
Yeah, then you go after the coach.
So
Yeah.
in,
If
in
that's
that
the
case, it's a violation of the section, but you have a claim against the coach as well. But
Yeah.
you already would have that claim. for them doing what they're doing. So I'm just saying, like, on that scenario, that they must have a separate claim independent of this to do that.
Well, I'm saying that if, as a coach, a student comes up to me and says, "Oh goodness, coach, I'm tired today. My mom was up all night doing drugs and drinking with her friends, and it kept me up." And okay.
The coach in that
And then
case
the
is a
father-
mandatory support, reporter.
And
He
then the
has to report that.
father, well, there was no, he didn't report anything. They were just drinking and drinking and drugging. If he said drugging, they weren't abusing or neglecting the kid. He was in bed.
I think there'd be an argument for.
Abusing
Well, there
drugs,
would be an argument. There's a debate. There would be a debate on that.
Okay, I
Of
think
course
we're
there would.
getting in the weeds.
Yeah, no,
So-
yeah. Well, no, what I'm saying is it's not as simple. Then the father of this divorced parent comes up to the coach and says, "Hey, is there anything going on with my son at the mother's that you know about?" And he's gonna say, "Well, your son told me yesterday that he was up all night. He's tired today because he was up all night.
So
Mom-
in
Mom
this-
was drinking."
In this, example that you're giving, it would be, I believe, policy for that coach to go to the guidance counselor in the school and talk to the guidance counselor about it and give them the information. And then if the parent comes to the coach, say, you know what, you should go talk to the guidance counselor about this,
Yeah,
right?
yeah.
That would be the right process,
also they're a mandated reporter, so
right?
if they're not willing to disclose that, make that mandated reporting, but then they tell
Yeah,
the
but
they
this
tell the
isn't-
divorced
this,
parent
This
that
isn't
person
black
that
and
coach
white
is all over the
mandatory
place.
reporter. I didn't hear nothing as a coach that the child was abused or anything like that.
If they're a minor and they have
Drugs
they're
and-
they're at practice, I mean they're the adults supervising. I would say so.
So if
They're under
somebody drinks all night and keeps the kid up, that's something that should be reported as a mandatory reporter. I don't think so.
Well, maybe some more facts might be needed. Just
I mean,
they
the fact that I stayed up all night and I'm.
they had a 4th of
13
July
years
party.
old.
I don't think is the case. But you
I mean,
mentioned
it's all,
drugs.
yeah,
Yeah, you did mention drugs.
yeah.
Right, can we,
I think
are you guys ready to move forward?
yeah, I think we can move forward.
All right, so I think I have
we,
to.
we don't
bring
get a
in the
chance to
amendment.
talk with Senator Long outside of these.
I do, I see him all the time.
Well,
Right.
because
Yeah,
of
we
the
can't
small
discuss this stuff though.
because of the small size of this, if myself and Senator Long wanted to have a conversation about this amendment before, that right to know law would, unfortunately,
Because we're so small, it ends up being like,
so
Yeah, we're.
I assured Pat that I would give him as much time as he wanted to.
okay.
Wait,
So I think
so-
we have to make a motion to approve amendment number 2025-0527.
So the motion right now is whether to adopt the amendment. I don't think we adopted it.
Okay, I make the motion to adopt amendment 2025-0527S.
And I'll second that to adopt the amendment. Well, the technical changes.
And then
So all those in favor of adopting the amendment?
I,
Aye. All opposed? So the ayes have. Now the amendment's adopted. Is there any further discussion? I think we,
I think we've
Yeah, we're
discussed.
discussed now.
is there a motion of ought to pass as amended?
Ought to pass as amended.
Second? So all those in favor?
Aye.
All opposed?
Pose.
The ayes have it, 2-1.
I'll take it out.
Can we,
Oh,
We
do you
move-
want to move to consent? Are you okay with consent?
No.
Okay, I'll take it out. So we weren't as close as.
Well, yeah.
Senator Long, I do appreciate
think
you
we are.
supporting
I
the
think
amendment
we
at
are.
least.
I-
I do
I
appreciate
mean, I
it.
think the intent is, I love the intent. I think parents need to be reminded of what their rights are. They need to know that.
And I, even though we didn't agree, I do appreciate that you still went through some of the statutory construction with us, and I hope we're putting the best bill forward, whether you support it or not. I do the same on bills I don't always support, so I do appreciate your involvement in the process.
I'm going to make a motion to leave executive session.
Oh, second.
Favor, aye.
Aye,
Aye.
we're done.
Adjourn. Make a motion to adjourn.
And before we do that, I think that this clears up all of our bills for now.
Okay.
I will say last term, the overwhelming majority of the bills came from the House on this. So we may have a busier, after Passover, may get pretty busy. So
So is it assumed that we're gonna get the children and family law bills that are in the House? Oh, you think? Or-
Yes.
I'm making that assumption, but yeah, that's it. So, all right, motion to adjourn. All in favor?
Aye,
Aye.
Thank you, gentlemen.
thank you.